Hi, I'm John Kelly. I'm an attorney practicing in vulnerable adult cases. We're doing a 7-part series. This is part 6, where I talk about the defense playbook. If you have questions about this, we're at Kelly Law Team, and you can always reach out to us at 602-283-4122. So the defense playbook, and we're going to cover how to burn it. If you've been watching the series, you're probably realizing something. Even when the harm looks obvious to you, the facility and the insurance company may still fight it. In this chapter, we'll talk about common defense tactics in vulnerable adult abuse and neglect cases, and how to counter them with facts, strategy, and a clear moral narrative. I'm here to help you understand and navigate what can feel overwhelming. We've covered how these injuries happen, what they look like, and how to report and preserve the evidence, and how the damages are built. Now, in this chapter, we're going to have to talk about the other side, because in civil cases, the defense rarely says, "You're right, we failed. Here's fair compensation." They have a playbook, and if you've handled these cases such as I have, you already know the playbook is designed to confuse, fatigue, and devalue your case. So let's expose it as best as we can. Common defense strategy number 1 we'll talk about. It was unavoidable. This is the defense's favorite word in facility cases, unavoidable. They'll say pressure injuries can happen, falls can happen, old people get infections, dementia patients wander. And yes, those statements can be partially true, but the defense hopes you'll stop thinking there. The counter is simple. Risk is not an excuse. Risk is a duty. If the risk was known, the facility was obligated to plan for it, staff for it, and execute care to reduce it. The question is not, could it happen? The question is, what did you do to prevent it? And did you actually do that? I'm going to give you a pressure injury defense example. So they'll say, she was at a high risk. Your response is, exactly. That's why turning schedules, skin checks, and moisture management were mandatory. Show me the turning logs. Show me the skin assessments. Show me the escalation. So they'll have falls defense, and here's an example. They'll say, he was a fall risk. Your response is, exactly. That's why toileting assistance, call light response, and transfer protocols were there and required. Show me the staffing and the response times. Show me whether the care plan was followed. You'll get a common defense strategy number 2, which is, it was pre-existing. It was decline. This defense is emotional and cynical. They'll take the resident's vulnerability and use it as a shield. They were old. They had dementia. They were sick. They were going to die anyway. This is where you reframe. A fragile person is not worth less. A fragile person needs more protection. And legally, the concept is often acceleration and aggravation. Did the negligence accelerate decline? Did it turn manageable fragility into catastrophe? A resident can have dementia and still not deserve a broken hip from an unattended transfer. A resident can have diabetes and still not deserve stage 4 wound from being left in one position for hours. A resident can have heart disease and still not deserve sepsis from untreated infection. As an attorney, I'll counter this with timeline, medicine, baseline function, baseline weight, baseline mobility, baseline cognition, then the injury event, then the steep drop-off. Juries can understand this cliff. They understand before and after. So a common defense strategy, a third one that we'll discuss, is the resident refused care. You will hear this constantly. She refused to eat. He refused to let us bathe him. She refused repositioning. He refused meds. She was combative. Sometimes residents do refuse care, but refusal is not a magic wand. In facilities, refusal should trigger a higher duty. They need to assess, document, figure out alternative approaches, behavioral strategies, family notification, provider involvement, and care plan revision. If a resident with dementia refuses, because they are fearful or confused, then staff must adapt. You don't respond to fear with neglect. As an attorney, strategies here include looking for whether refusal is documented consistently or only after harm. We look for whether staff tried alternatives or simply charted refused and moved on. We look for whether family was notified and look for whether a physician was consulted. We also look for whether there was any care plan changes after repeated refusals, which is important. A chart that says refused over and over without a plan is not a defense. It's an admission of system failure. I'll now talk about common defense strategy number 4. They'll say we documented everything. Documentation is not care. Charting is not turning. A signed flow sheet is not feeding assistance. Defense will often try to use a chart like a shield. See, we did it. Your counter is, well, show me the credibility. In electronic records, you look for identical copy-paste entries and possible timing, gaps where care supposedly happened but no one was staffed to do it, audit trails showing late entries after an incident. You'll also compare the facility chart, the hospital chart, EMS notes, the family photos, and witness testimony. When the narratives conflict, the defense loses the documentation equals truth advantage. So we'll talk about another defense strategy, which is number 5, understaffing isn't negligence, it's reality. This is the labor shortage defense. It's the we did our best defense. Let me be blunt. A vulnerable adult is not supposed to pay the price for business decisions. If the facility accepted the resident, collected payment, and promised care, then they had a duty to staff appropriately. If it chose not to do so, that is not a tragedy. That is negligence, often considered corporate negligence. As an attorney, this is where staffing records become our gold. Assignments, call-outs, agency usage, hours per resident day, and deposition testimony from frontline staff who quietly say the truth. We didn't have the time. We were always short. We didn't have what we needed. Those statements are not excuses, they're admissions of foreseeability. As an attorney, they're very usable in your case. Now we'll talk about common defense strategy 6, arbitration. You signed away the courthouse. Many facilities push arbitration agreements during admission. Families are exhausted, scared, and signing stacks of paper. Sometimes the resident lacks capacity. Sometimes the signer doesn't have authority. Sometimes the agreement is buried or misrepresented. I'm not going to give you state-specific legal advice here because that enforceability depends on facts and the law of your state, but conceptually, attorneys like myself often need to evaluate whether the resident actually had the capacity to sign, and did the signer have the legal authority or power of attorney guardianship. Was the agreement a voluntary signature or pressured? We also ask, is it procedurally unfair or substantively unfair? Does it cover intentional torts like assault? Are there carve-outs that matter? Was it properly executed? For families, don't assume that signing something means the end of the road. Get it reviewed and don't sign new papers after an incident without understanding them. We'll now talk about common defense strategy number 7. It was someone else's fault. Facilities sometimes blame the hospital. They came in like that. The family, you didn't visit enough. Another resident, we can't control other residents, or even a victim. They're just clumsy. The counter here is responsibility. A facility is responsible for the safety of its residents within the scope of the foreseeable risk. If a wound was present on admission, then the question is, what did the facility do next? Did it assess, treat, monitor, and escalate? If the resident-on-resident violence occurred, the question is, was the risk known? Were the prior incidents documented? Was the supervision adjusted? Were residents separated or protected? If the family didn't visit daily, then the question is, why does your business model depend on unpaid family labor to prevent neglect? Common defense strategy number 8. The injuries didn't prove abuse. This one's subtle. They'll say bruises happen, skin tears happen, infection happens. They'll call injuries nonspecific. Sometimes an injury is nonspecific, but patterns are specific. Multiple bruises in various healing stages, repeated falls, weight loss plus dehydration, pressure injury plus incontinence neglect, sedation plus falls, infection plus delayed escalation. Those are not random. They are a system talking. This is when your narrative matters. Instead of arguing each symptom is in isolation, you show the chain of events. Common defense strategy number 9. This case isn't worth much. The defense will try to devalue the human being. They will try to talk about the age, illness, and life expectancy of the person. They will treat the resident like a number. Your counter is dignity and pain. And as an attorney, the anchor is in the evidence. Was there wound photos, hospital records, pain notes, family testimony, and expert explanation of the suffering? A stage 4 pressure injury is not minor. Sepsis is not minor. Aspiration pneumonia is not minor. Sexual assault, not minor. And juries often respond strongly to moral clarity of these cases when presented with respect. Now, one more strategy point that is important: credibility. The defense often attacks credibility because it's easier than defending bad care. They may say the family is exaggerating. They may suggest the family is motivated by money. They may nitpick small inconsistencies, which is very common. So as the plaintiff's side, you do 3 things. First, you tell the truth plainly, even the inconvenient parts. If the resident had dementia, you say it. If the resident had prior fall history, you say it. You don't hide reality, you frame it. And your attorney, like myself, can help you with this framing. Second, you focus on the strongest, most provable failures. Not every complaint needs to be in the case. Pick the failures that are documented, repeated, and clearly tied to the harm. Third, you humanize without melodrama. You don't need to scream. Let the facts breathe for themselves. A photo of the pressure injury doesn't need a speech. A timeline of weight loss doesn't need theatrics. A hospital record documenting dehydration speaks in cold, clean voice that juries will trust. To conclude this chapter, the defense playbook is designed to make the harm seem normal, inevitable, and unprovable. Our job is to show that it was foreseeable, preventable, and documented. And when you do that, the playbook burns. Now, having walked you through cases, settings, injuries, reporting, proof, damages, and defense tactics, it's time for our final chapter, bringing it back to the human journey. In the next chapter, we'll talk about the family's fight after suspecting facility abuse or neglect, and how families protect their loved ones without collapsing under guilt, how they navigate moving facilities, dealing with agencies, and dealing with the emotional aftermath, and how the legal process unfolds from investigation to resolution when the goal is not just money, but accountability and safety. Now, after going over this information, if you have questions or have a loved one that's a vulnerable adult that needs help in the legal sense, we're happy to help. We have help people nationwide. You can reach us at Kelly Law Team at 602-283-4122.